landmark judgment which clarifies that when tax authorities must process refunds despite their intention to appeal. The Delhi High Court delivered a clarity on a critical issue. Can tax authorities withhold refunds simply because they're planning to appeal, they're proposing to appeal on the order which is granting that refund? This case involves around the assessee which had successfully challenged the refund rejection order before the objection hearing authority, and he won that appeal, but still he is finding himself to obtain unable to obtain the rightful refund of rupees 18 lakh rupees. The tax department argument hinged on the section 5411 of the CGST Act. They claimed that since they had decided to file an appeal against the refund order, so that is why they are withholding the payment indefinitely, even without actually filing that appeal. Section 5411 states that refunds can be withheld where an order giving rise to a refund is the subject matter of an appeal. The tax department interpreted this to mean that merely deciding to appeal was enough to freeze the refund processing. The High Court here stopped them and rejected this interpretation, making two critical observations. The first, that the statute refers to the orders that are the subject matter of the appeal, not the orders that might become the subject matter of the appeal, right, in the future, because right now they have not filed the appeal. Second is that a mere decision to file the appeal cannot automatically suspend the operation of a valid order, right? The court also relied on a judgment in the case of Alex Student Travel, which established that revenue cannot refuse to comply with the appellate orders on the grounds that it proposes to appeal, it plans to appeal for that particular said order, right? The court clarified that the proper procedure must be followed. The first, tax authorities must either comply with the appellate order granting the refunds, or they can obtain a stay order from the competent court, right? And without such a stay order of the refund, they must process that refund promptly, right? Simply planning or even filing an appeal does not suspend the order's operation. And here the court also ordered that the payment of statutory interest under section 56, emphasizing that unjustified delays have financial consequences for the department, right? This judgment is very important. So what are the key takeaways for all the GST taxpayers here? The first one is that refund orders by the appellate authorities are immediately enforceable, right? Second is that tax authorities cannot delay refunds by just merely indicating an intent to appeal, right? Third one is that only actual stay orders from the courts can justify withholding the refunds. Fourth one is that taxpayers are entitled to interest for delayed payments, right? The judgment was very important, and if you have won any refund appeal, right, but you are facing similar delays, this judgment